Welcome to the award ceremony honoring Henry Smith. I am Linda Butler, the faculty director of the Brigham-Kanner Property Rights Conference. Before we get started, let me give you a few Zoom logistics. First of all, your mic and your video should be off unless you are speaking. We also will have a Q&A session at the end after Henry makes some remarks, and we have a student co-host, Casey Couch, who will be asking the questions. She will be collecting them and then asking the questions. Right now, then, those are all the logistics for now, so I'm going to turn it over to our Dean, Ben Spencer.
All right. Good evening, everyone. Welcome to the 17th Annual Brigham-Kanner Property Rights Conference. And this is also the 17th annual presentation of the Brigham-Kanner Prize for Excellence in Advancing Our Understandings in Property Rights. And what I want to do just briefly, and I'm not going to take up too much of your time, but of course I want to welcome you here. I wish I were welcoming you in person to the law school. We have a beautiful campus, a beautiful building, and ordinarily we'd be down the street from where I am in the Wren building, which is one of the oldest buildings in the country, and it's a beautiful facility, and hopefully we can return to it next year. But this is a very historic place. As most of you probably know, Harvard, which is the home institution of our distinguished honoree, and William & Mary are the nation's two oldest universities. Now, this university was chartered in 1963. It's often referred to as the alma mater of the nation. And the reason behind that is because of its educational ties to many of our nation's founders, including we've got President George Washington, who got a surveyor's license here. We've got Thomas Jefferson, James Monroe, John Tyler, among others. And we count John Marshall among one of the alums of this law school. So it was in fact Thomas Jefferson in 1779, when he was the governor of Virginia, he decided to create America's first professorship of law. And he wanted to do that to have well-trained lawyers who would become citizens and have a public service ethos who could support our nascent democracy. So it was that vision that gave birth to this law school. He ended up tapping his mentor who had trained him in the law, George Wythe, and George Wythe became the first law professor in the country, and America's first law school, William & Mary Law School, was born. So now we are in our 241st year, and we're still going strong. And I've got to say that this institution as a whole, this law school has come quite a long way, because even over the course of all of those years, there were some imperfections, not everybody was included. So to get to the point now today where I've become the first African-American dean of this law school and at any school at this university, I just think it's a great testament to how much progress we've made in this country, how much progress this institution and this law school has made. So what I want to do now is give a few thank yous, which are very important. So first of all, I really want to thank Joe Waldo. We gathered this evening because of Joe, who was one of our illustrious alums. And he's a member of one of our greatest classes, the class of 1978. And it was actually Joe's idea to create a program in property rights law at this law school. And it was Joe's generosity that has enabled us to begin developing this concept. So to Joe, Mr. Waldo, we are all in your debt. I really thank you. This is a tremendous legacy. I know you're extremely proud of this, as are we. We couldn't be more happy to have this be at home at this law school. I also want to thank Linda Butler, who you saw at the top. We're here tonight because of her extraordinary and tireless work. She's labored long and hard to bring this conference to fruition. I know it's a labor of love. It's her passion that I really admire. So thank you, Linda, for your years of extraordinary dedication and service to this event. And I also, of course, want to thank Allie Trevette, who is one of our event planner here at the law school. She has engaged in tireless efforts, many hours planning this conference, handling countless logistical matters, making sure everything goes off smoothly as it always does, thanks to her. So she's fantastic. All right, so let's get on with why we are all here, which is our honoree, Henry Smith. So there's going to be much more about Professor Smith's work later tonight and obviously tomorrow. So for now, I just want to say it's just quite an honor for me to be part of this. Henry and I were together. I was at Harvard Law School last year teaching before I took this job, and Henry's office was right around the corner. And I could always look forward to bumping into him and his smile, having lunch with him on several occasions, and talking about the issues of the day. And it became, it's very apparent how brilliant a legal mind and a scholar he is. So it's very, it's fantastic for me to be able to be part of this. It's just wonderful to be able to honor you tonight. And it's also wonderful to be able to welcome your family here, your wife, Sanju, and your daughter, Hannah. I know they are very excited to be part of this. And I know they're a big part of your success. So we're happy to welcome them. So what we're going to do now is we're going to have Andy Brigham. He's going to come and talk about the origins of the conference. And after he finishes, he's going to hand it off to Linda Butler, who will introduce our honoree and say much more about Henry. So Andy, if you can go ahead and take it away.
Thank you, Ben. And the 17th Annual Brigham-Kanner Property Rights Conference, one of the things we've been looking forward to, Ben, is actually having you arrive. And this is the first year that marks you being the dean of the law school. And just thank you for already how much support that you're providing the program in your position as dean. I want to paint the context for the prize that we're honoring Henry Smith with tonight. And really, I guess because it's a property rights conference, I'm going to paint what I call a landscape. I'm trying to put the context of why we are here in terms of looking at private property and its importance to protecting individual liberty. You know, the civil right of private ownership is a little piece of sovereignty that each and every one of us has. And because each and every one of us has that sovereignty that's ours, and that it's something that checks and balances the power of government, it really does make us more free. And I think the beauty of this program and the vision and the genius of it has been to go to the academy and to bring the academy together with the practicing bar and to hold a conference where we really are looking at not just property rights in terms of its theory, but property rights in terms of its application. And we have such a wonderful historic context to do so at the law school at William & Mary. And I want to, if you will, just take a moment and think with me how this conference really did come together. And I have some visual aids to help us in that endeavor. I think Ben mentioned that this conference would not have begun except for the good thoughts of Joe Waldo and Taylor Reevely, who was the dean of the law school at the time. And because of their vision, they established a program that we all enjoy today. And I just want to remind everyone, it's a demonstration of the importance of the academy and the practicing bar coming together. I know that Joe and some of his other alumni very much wanted to found this program, but if they didn't have a willing partner, someone in the academy that saw also a common vision and purpose, it never would have happened. And Taylor was a wonderful supporter of the program, not only as dean of the law school, but when he became president. We were also very fortunate that Joe, and perhaps me more than anyone, decided to name the conference after two individuals that would really embody and symbolize what it is to be a legal scholar and a legal practitioner devoted to property rights in our time and place. So on one hand, I have my father, and that's Toby Prince Brigham. And on my other hand, I have Professor Gideon Kanner. The two of them were very good friends and still are. They were the brightest stars within their different spheres. And it has been a great privilege to have a program that has looked to their example. And I just wanted to remember them tonight. Our program now has 17 years in its making. So one of the things that we have done is come together on an annual basis. And one of the things that we enjoy is the camaraderie that we have. This is something that is a little more challenged in our video conferencing setup tonight. And I truly do miss the opportunity to come to Williamsburg and to see who become good friends of mine, who also are very interested and devoted to private property rights. Our conference in the 17 years, we have had a great place to gather at Williamsburg, and on occasion we have gone elsewhere. So we have been to China. That was in 2008, and then in 2016 we have gone to The Hague. And I have some pictures behind me just to remind those that were on those two trips how worthwhile it was, and how we see that the property rights laboratory that we have here in the United States also is valuable as we take those ideas and share with other academics and legal practitioners throughout the world. Again, this would never happen unless William & Mary, the law school there, unless they saw a purpose in a plan and a vision for bringing us all together and doing so on an annual basis to concentrate our focus and our attention on property rights. Lastly, and I really do enjoy this because I think this also is so helpful to have the conference at a place where we really are espousing the academy and the practitioner coming together. And we have no greater picture of that than George Wythe and John Marshall. And when we think of their relationship, it's a beautiful thing. It's beautiful what George Wythe poured into John Marshall and what John Marshall was able to take. And I think how important it was in the early establishment of our country that these two men were in that relationship, a professor and a student of the law. The thing that I think we can admire about George Wythe is also a tribute to George in his legacy. And it's been noted in two important historical items. I have them with me. Every year that I'm able to present, I do try to think of something historic that will remind us, what our foundation is built on and where we're going with it. So this year, I thought it would be a very important fact for everyone to remember which came first. Was it the brass plaque, which is sitting behind me? Or was it, if you will, the marble panel? Now, we can't have audience participation, but I try to ask every William & Mary Law School alum, which came first? Was it the brass plaque or was it the marble panel? And I'm going to tell the answer tonight so that you all who are participating by video conference, you'll get the answer correct if I ask you in years to come. But what came first was actually the brass plaque. The brass plaque was a tribute to George Wythe. It was purchased by the Virginia Bar Association in 1893. That was a special year because it was the 200th bicentennial of the college being founded. Now, the plaque hung prominently in the Wren building in its chapel, and it was mounted on the oak walls. But the Wren building was renovated in 1927, and the brass plaque was replaced or substituted by the marble panel. Where you will find the marble panel today is right where it was put in 1927. It is in the chapel of the Wren building. But where you will find the brass plaque, it's in the law school, and it's in the lobby. I want to remind everyone, because I think it's a wonderful picture of the hope that George Wythe had in his student, John Marshall. And it really was something that everyone wanted to give as a tribute to George Wythe, and it's engraved on both the plaque and again on the marble panel. And it sits behind me, and you might be able to see it if I kind of slide a little this way. But the inscription is again, to me, very inspiring because it paid tribute to George Wythe on these points. His courage as a patriot, his ability as an instructor, his uprightness as a lawyer, and his purity as a judge. And I would challenge all of us as we come together and we devote ourselves to private property rights and the importance in protecting our individual liberties as a guardian of those rights. These are very important characteristic and elements in the roles that we all share at different times with one another. For those that are patriots and love our country, private property rights is such a foundation of civil liberty. It does guard other rights that are so important to the quality of life that we enjoy. The respect we have for one another, the respect we have for property, they go hand in hand. Also, when we talk about instructors, those law professors, Henry, tonight, I think one of the things that has come so much across to me as we've talked about the award and what it's meant for you, it's the fact that the prize that's honoring you also honors those that are both your mentors and your colleagues. And you've been the person to acknowledge that. And unfortunately, we're not together tonight at a dinner to celebrate, but I do know that so many are extending their respect to you. And as I told you, you are not only a respected scholar, but you are beloved. The folks that have been able to be your colleagues, those that have taught you, they express how much that they appreciate you. And that's something that Sanju and Hannah, you as family tonight, please know that that your husband and your father are being honored in both of those categories. As lawyers, if we can have uprightness, think how much our profession would benefit as we practice law in an ethical manner, and we really do seek justice and fairness, particularly in the balancing of property rights, which is so important to check and balance that element of human nature and government. And then lastly, purity as a judge. What a characteristic to have in terms of approaching the law, a desire to want to be pure and to have equity in law, both to dispense and to make sure that people are treated with respect in accordance with their basic civil liberties. I just share with you this night that we are so pleased to have Henry Smith receive the award. And I hope that I've been able to, again, remind you what a special conference that this is, the Brigham-Kanner Property Rights Conference. And it is so wonderful that even though we're not able to be together in Williamsburg, Virginia, we do appreciate how many have registered tonight and are here to honor Henry Smith. Thank you.
Andy, those are wonderful and very warm remarks, and we all truly appreciate them. Each year, the Brigham-Kanner Prize is awarded to someone who has made significant contributions to our understanding of property. Prior recipients have included the nation's leading property scholars, a Supreme Court justice, a leading practitioner, and a Peruvian economist. This year's recipient, Henry Smith, is one of the deepest thinkers we have recognized. By that, I am referring to Henry's ability to innovate, introducing new methods and ideas about property that have led to the emergence of a theory of property focusing on its architecture. Whether it is his work on the relevance of an old doctrine, his explanation of the interface between contracts and property, his insights into well-managed semi-commons, or his work on two strategies for delineating the nature and scope of property rights, Henry continues to push the boundaries of property theory in ways that reveal its complexity. Very few scholars can take a seemingly obsolete doctrine like numerus clausus and give it modern relevance. Very few can bring property from what critics predicted was its demise, its disintegration, to its reemergence as a powerful system. His analysis is complex. Reading his work is not a leisurely walk in the park, but the lessons learned are so invigorating that the careful reader will inevitably have an aha moment. Henry's numerous publications include books on property, on patent, on economics of property law, and on linguistics. He has also published many articles in the top journals, including Yale, Harvard, Columbia, Michigan, Chicago, and William & Mary, and the Brigham-Kanner Property Rights Journal. A member of the American Law Institute, Henry is the reporter for the Fourth Restatement of Property, a monumental task. Professor Smith received his AB in German Studies from Harvard, an AM in German, and a PhD in linguistics from Stanford, and a JD from Yale. After clerking for Judge Winter on the Second Circuit, Henry joined Northwestern law faculty in 1997. He returned to Yale as a faculty member in 2002, before joining the faculty at Harvard in 2009, where he now directs the project on the foundations of property law and is the Fessenden Professor of Law. Both academics and practitioners have praised Henry's contributions. When she was the dean of Harvard Law School, Justice Kagan praised Henry as one of the nation's leading lights in the crucial fields of property and intellectual property, and as producing scholarship that is as original as it is rigorous, as brilliantly interdisciplinary as it is deeply rooted in the law. Bob Ellickson described Henry as universally admired and a leading property theorist. And Joe Waldo, whose commitment to property rights led to the creation of this conference, described Henry as a remarkable scholar and praised his leadership of the Fourth Restatement. Joe especially appreciated Henry's recognition of the importance of practitioners to the restatement project. Henry, we are deeply honored that you are here virtually to receive the Brigham-Kanner Prize. And now I'm going to do a virtual presentation of the prize to you. And this is what I've been worried about the entire day, because this is very heavy. But here is the prize, Henry, that we are giving you. And it's a beautiful crystal that we will mail to you. I'm turning it over to you now, Henry.
Thank you so much, Linda. That was such a kind and gracious introduction. I have to say that not only am I honored and humbled to receive this award, and I will say I'm not virtually honored and humbled, I am actually honored and humbled to receive this award. It's really a surreal experience, because this conference I've attended many, many times. I consider it the sort of high point of the property year, and I've always enjoyed this conference very much. I've always profited from it greatly, and your leadership of the conference has been incredible. You've stimulated people to really do their best work. So my thanks, first of all, to Andy Brigham and Joe Waldo for making this award and conference possible. As I said, this is really a boon to the whole field, and really the high point of the year for people in the field of property. And it's one, as was mentioned, that brings together the whole property community, academics and practitioners and judges, which is incredibly valuable for obvious reasons, but also ones that I'll talk about in a moment. I'm also very grateful to my former neighbor, Dean Ben Spencer, as well. The William & Mary Law School is incredibly incredibly lucky to have you as their leader. And I really appreciate the William & Mary Law School and Ali Trevette for handling everything so well here. If there's any group I'd be thrilled to join, and I am thrilled to be joining, it's this group of Property Prize winners. I looked over the list again today, and I really didn't have to do it. I think I could have actually recited them from memory because they are really a super group, and it's really kind of hard to believe that that I'm joining them, not just at a conference, but actually joining their ranks. That group includes, I'm not going to go through the entire list, but people with whom I have a deep friendship, two valued colleagues, Frank Michaelman and Joe Singer. It includes two of my friends and mentors, Bob Ellison and Carol Rose, who taught at Yale when I was a student, and my longtime friend and collaborator, Tom Merrill, and I'll have more to say about that in a minute. So I'm definitely surprised to be a part of their revered company, but I'm surprised for other reasons as well, because I did not know always that I would be a property person. I did not think of myself as a property person when I went to law school, while I was in law school, or even after I was in law school. But I would say, maybe with a little bit of revisionist history, I always was a property person, and let me explain how that works. I came to law school having done a PhD in linguistics, and I'll sort of say what the connection is later, but the connection really wasn't apparent at the time. I did not set out to do law and linguistics, and that wasn't really, I wanted to take law on its own terms and see how things went. And when I started teaching at Northwestern after my clerkship, my wonderful clerkship with Judge Winter, the law school tried to get me to teach property, and I actually argued them out of it, which is a testament to how nice the people are at Northwestern, because usually when, for curricular reasons, they ask a junior faculty member to teach a subject, that's not really a request. But I made some argument about how, yeah, I was hired to teach commercial law, and so I should start with contracts and so forth, and they actually bought the argument. Well, little did I know that they were right and I was wrong. And because at the time I was trying to apply new institutional economics, which I retained an interest in particular the property rights economics of writers like economists like Yoram Barzel, to the question of how we give remedies in contract law. And I think it's still a good idea, but what happened was that during the course of the gearing up for this, I ran across the puzzle of the medieval open field system, the system of scattered strips that would be thrown open for common grazing after harvests and in fallow periods. And this was always treated as a puzzle because these long, thin strips seemed to be very inconvenient, and so explanations, if that's what they can be called, ran from things like people just didn't know better, or maybe there was some insurance involved, and some of these were very interesting explanations. And so I thought I had some idea that maybe this was a way of constraining strategic behavior in certain ways, and so then I thought, well, okay, that's kind of an interesting idea. Maybe I'll write a little paper on that and then get back to business with contracts. So take a little tangent and then get back to where I was. And I'm still on that tangent. So I never got back to business, and here I am. And I'm very glad of that. So basically, as Linda mentioned, I came to property through contract. I was both writing and teaching on contracts, and encountered property questions from time to time, and and I certainly thought back to Bob Ellickson's property class when I was doing it, and it was really quite puzzling, because the idea that property facilitates bargains and promotes human flourishing, people's projects, allows them to conduct economic activity, and so forth, all sorts of activities that are protected. And it has its limits based on anti-discrimination, public policy, excessive restraints on commerce, and so forth. So there were a lot of similarities, and I thought, well, that's not surprising, because a lot of people said, private law is private law, and maybe all law is law, and there really shouldn't be anything special about areas of law. And yet, property did seem to be special in a variety of ways. And in particular, even though in many of its guises, not all of its guises, property like contract was sort of facilitative, that people, it was a platform for people to do their thing. It still was very different from contract in that there was a lot of it that was mandatory, that property law tells you, okay, if you want to do this, then you have to use this form. You can't, you just can't make up your own form. You have, here's a menu of forms to use, which is not the way that the contract law works. And this and various other aspects were kind of puzzling. And one day I dropped by my next door neighbor at Northwestern, who's none other than Tom Merrill. And I have to say that it's hard to imagine as fun a neighbor. You could just drop in anytime, and that was one way to spend the afternoon. And it was very productive because when I mentioned these things that were puzzling me, he said, well, actually, there's a name for that, and it's called numerus clausus. And so we started talking about why property is standardized and why it serves its purposes the way it does, and maybe there is something to the idea that property is in rem addressing the world at large. If I have a property right, I'm holding it with respect to everybody in many cases, and that's very different from contracts. So we had these very productive conversations. Over time, I realized that this is very relevant to a whole gamut of issues in property law, from mortgages to customary law and so forth, where who the participants are and their sort of social distance from the thing itself and the people who are asserting the rights is very important. And one thing led to another, because these puzzles sort of went from puzzle to puzzle, and property obviously is not formalized all the time. It's not a system of purely mandatory rules, and part of property is very context specific. And we have trust law, we have equity. Actually, on the brass plaque and the marble tablet behind Andy, it noted that George Wythe was a judge of the Chancery Court, which we don't have many Chancery courts anymore, but the element of equity in our legal system is very important, and I'd like to talk a little bit about that tomorrow. But the idea that property law has this complex and hybrid character where it's doing many things at one time is very, very important. So looking back, I realized that I was actually always a property person. I was Bob's RA on his land use book, and I was a director of the Landlord-Tenant Clinic with the late Frank Deneen at Yale. And I was trying to remember sort of at what point I kind of got an idea of why I was a property person, because I'm making this sound like one thing led to another, and that's basically what it was. But I remember a workshop dinner at Yale, and Bob and Carol were both there. And the paper was somewhat property related, and we started getting into this highly raucous and wide-ranging discussion about property. And I don't think I can even recall all the things that this conversation touched on, but I think it included water infrastructure and land records, and I don't know what else. And I realized that, maybe to borrow a phrase, property is about life in all its fullness. And I think that's very important. And at the same time, it's a very specific set of institutions. These are important institutions that need our urgent attention precisely because they touch upon life in all its fullness in all of its aspects. And what could be more important? Consistently with that, when Ricky Revesz asked me to be the reporter for the Fourth Restatement of Property, I certainly was somewhat hesitant. I'd always been kind of skeptical that this could work. And I convinced myself, partly because of what I just said, that property is important. It's an important institution. It deserves attention for what it's doing in so many facets of life. And I thought that there's something that maybe past restatements did, but we could do again, and maybe even more completely. The first restatement was only actually a partial restatement, unlike the torts and contracts restatement. And I thought there's maybe a possibility that we could do something that's both systematic on the one hand and flexible and empirically grounded and sensitive to the real world on the other. That's a very tall order. It's something that no one person could possibly even begin to to do. And it requires all sorts of different kinds of creativity and expertise as inputs to a project like that. And I've been very fortunate to work with many different people with many backgrounds on it. The team of associate reporters is an outstanding one, and a total pleasure to work with. And many of the people are here today. It includes Molly Brady, Sarah Bronin, Rick Brooks, Wilson Fryermuth, John Goldberg, Dan Kelly, Brian Lee, Tom Merrill, and Chris Newman. And in the spirit of this very prize, we've really benefited, all of us, all 9 of us have benefited from the expertise and wisdom of practitioners. And included in those are people on the program and involved in this conference like Steve Wise and Joe Waldo. And many of the academics here today are also advisors on the project. And as I said, this kind of project requires many kinds of wisdom as an input, and I'm deeply grateful to them. Creativity in the service of making things work is something that is really hard to appreciate unless you actually try to do it. As a result of the restatement, I've been drawn into areas of property that I never thought I would do. So more on the theme of sort of one thing after another. And maybe we'll talk. Maybe I'd be happy to talk in the Q&A about some of them. These areas include drone trespass and conversion of intangibles, trespass on the internet, and things like that. Sort of cutting edge issues. And I realize when I teach first year property now that if you want to include cutting edge issues in the property class, it's kind of hard to do. I think it's valuable to do, but it's hard to do because they often come in at the point where very basic concepts enter the course, like possession and trespass and so forth. And I think that says something very deep about property, that it's precisely in those areas where the accommodation of important technological and social change may pop up, may demand some attention in the law. And that connection to reality is actually why I went to law school in the first place. I loved linguistics, but I thought it was time to get real, and that's really the way it turned out. As it turned out, what I did in linguistics, I think, was more relevant than I thought at first. All sorts of aspects from the ancient Indian grammarian Panini, who I studied in grad school, to the sociology of audiences in discourse. They all proved more real and more property related than I ever thought at first. And so for me, this is kind of an occasion to think about how all of this actually fits together, at least in retrospect. But some of that's a topic for tomorrow. So that brings me back to the beginning, which is how I got into academia in the first place, which is linguistics. So as Ben said, my family is here, my wife, Sanju, and our daughter, Hannah, and I certainly thank them most of all for their support. I met Sanju while we were working on problem set groups. Problem sets, we formed our little own 2-person subgroup for problem sets. And I remember thinking at the time what a miracle it was to be working with the most amazing person in the world, and it's been like that ever since. So thank you.
Well, Henry, that was a wonderful way to end your remarks. I am going to start the questions, and then I am hoping that others will jump in. But my question is, you mentioned that trespass on the internet is fitting into the restatement project, and I was hoping you could sort of explain how.
Great. Well, so starting in the 1990s, the whole question of whether the old tort of trespass to personal property should be dusted off and used to regulate, or that people could use this to regulate access to their websites became a question. And it's still a question because you might think, and most people don't think, but one might think, especially if one were a plaintiff, that, well, if somebody comes onto my website and violates the term of service, that's sort of like somebody coming into my house and for a dinner party and then looking through the medicine cabinet. As soon as they do that, they're a trespasser because they exceeded their permission. And the permission on the internet tends to be in the form of very elaborate terms of service that nobody reads. So at the same time, there was this worry in intellectual property circles that if we allowed trespass to apply in a sort of full-blown way to the internet, that it would get in the way of the openness of the internet. And yet, there do seem to be customs of the internet, Oren Kerr has written about this, that mean that, there are certain ways that trespass might be able to apply. And this is one of those areas, and I think there are quite a few of them, where the sort of emerging customs of the internet, I think, do sort of inform what we should think about trespass. So if you have to steal a password or hack in and so forth, then there might be a case for applying trespass to personal property in the context like that. And more generally, in terms of conversion, we did not want conversion to be a sort of backdoor intellectual property. And yet there were situations where, and courts are all over the map in terms of applying conversion to intangibles, but we thought that there were certain very extreme denials of access where you forge a definitive registry like in domain names, or you deny all access to one copy of a file and so forth, that do sound like conversion, that for functional and moral reasons, and we can have some liability in that area, that the property liability is important, but only up to a point. And so that's kind of what we're struggling with, and we consulted with many people. Steve Wise is one of them, because this question about the digital economy is really to the fore in a lot of different projects, both at the ALI and around the world.
So if I may, Henry, those were fantastic remarks. Thank you so much. And our student Casey Couch is going to be moderating and asking questions that are appearing in the chat. But before I turn it over to her, I'm just interested as a member of the ALI, knowing or hearing firsthand from someone who's leading a project, what's the biggest challenge there? And it could be an intellectual challenge, or it could be a practical leadership or logistical challenge. But just what has been your experience as a leader so far?
So I think sort of substantively, one of the biggest challenges is kind of in a big project, especially like this, is sort of knowing where to begin, because even though I would be the first to say that property has an architecture and it has certain well-worn grooves of connections and so forth, there are so many interconnections between the areas of property law that it's as soon as you take up anything, it's possible to start worrying about how it affects something else. And so working with many different groups and doing things provisionally and allowing yourself to just jump in and do something, even if it has to be revised, is very important. And in the process of that, I think one of the sort of on a more interpersonal level, I think, and I know you also do drafting projects. I think when you draft something, I think it's very important to realize that it sort of has a life of its own, and you have to put it out there for it to be shaped by other people. And you can't get too invested in it, because if you were, you'd have to you worry about, did I think about every last implication? Well, nobody could possibly think about every last implication when you've got a project of this size. So you just have to put it out there and let the evolutionary process kind of take its course, when you try to guide it, but not to sort of talk yourself into a corner too early on in the process. And I think that's something that I went in trying to do, but I think I've learned to do it better now after half a decade than I did at first, because there's really no way to learn how to do that except by doing it, I think.
Well, thank you. And now I'll turn it over to Casey. She's been monitoring the chat. And Casey, do you have a question for us from the group?
Thank you for that introduction, Dean Spencer. Yes, we have many questions for you, Professor Smith. So to start, can you please preview what you plan to say tomorrow about equity in property?
Yeah, so tomorrow, I am prepared for tomorrow. I think I'll probably do a little more preparation, but I plan to talk about a theme in property that uh, property often comes along a spectrum. Property is often some kind of hybrid, and I think that plays itself out in a lot of different dimensions. And one of those dimensions is law and equity, and I got into equity through property, and I've worked on equity for now about 10 years. And my basic idea is that despite the idea that, well, the reality that we've fused or merged law and equity courts, that equity serves a very important function. That historical equity jurisdiction did a lot of different things, but there was a theme through a great deal of it, that equity intervenes in the law when it goes off the rails. And it's not always intervening, but there are rules of thumb for how to get there. But once we're in equity land, the way maybe Carol Rose would put it, once we're in equity land, we're now much more contextual. We refer to fairness and morality in a very direct way. It looks all very ex post. It's very easy to misunderstand, but it's a different mode. It's a mode, a sort of meta mode, a meta law mode. That's very important. And if you look at property and all aspects of private law, and including some aspects of public law, as having this structure, then all sorts of possibilities open up that we can be pretty general and simple a lot of the time, but then when we really need to, we can focus on, say, opportunistic behavior in a very effective, very targeted way. And the specialization of different parts of the law makes the law better than the sum of its parts. And one of the themes I'll talk about tomorrow, and I think Linda mentioned this, is a theme of complexity and how to manage it and how to organize it. And by having two modes like that is one way of being, I think, more effective. So I plan to talk about that, and among other things, hopefully at not too great length tomorrow.
Speaking of complexity, a complex question for you from Wendy Kellington. She says, "Thank you. And you mentioned drone trespass. How do you analyze that? Do you borrow from Cosby and the old restatement regarding airspace intrusions? Do you borrow from the Fourth Amendment search precedents?"
Yeah, so I think in terms of the how to handle aerial trespass, I mean, this is a work in progress. I just said, not to get too invested in. There's certainly a lot of input coming in about this. Cosby and many cases, Cosby is one of many cases that was like this from the mid 20th century. That on one level created a special regime for airplanes, and it's true that when airplanes came along, people knew that we're not going to let trespass liability get too much in the way. But it's often forgotten that these courts were also very interested in protecting landowners against genuine harm, and they realized that landowners had an interest in airspace more than 1 millimeter off the ground or 1 millimeter off the top of their buildings and so forth. And it's kind of interesting that if you look really closely at how Cosby and these other cases arose and how they couched it, and the second restatement of torts, they were very interested, especially in airplanes flying at altitude. And they knew that airplanes took off and landed, but there typically people would acquire an easement and so forth. And obviously the FAA had a lot to say about flight patterns, and we generally have air navigation. What they did not talk about was sort of at the lower levels. Airplanes don't hover and so forth the way that drones do. And so we are, in a sense, we face the problem that Cosby didn't. So Cosby declared, well, this principle that you own to the heavens and the depths below never really applied. What they meant by that, it's a very snappy phrase. It's like, that was not the law, and that's not the law, and it never was the law. What they meant by that was that this literal idea that you own to the edges of the universe really was never true. But then the next breath, they said, oh, well, look at all these low level intrusions. And, like if there were elevated train that went over the house with no pylons, that'd still be an intrusion, and that'd be a trespass, and so forth. And so some of the questions that airplanes just left out are in need of further specification. And that's the sort of vision I have about this, is that this is sort of an ongoing specification of the nature of what land is, and very crucially, what possession is. So our solution to the problem is to recognize the need for Cause B to stay the way it is, for drones to be able to operate, but for the balance between landowners and drones to be taken care of in a somewhat more articulated way. Namely, that, and this sounds a little bit like the Fourth Amendment, but the Fourth Amendment is very tricky. But the idea is that people own to the level of their activities and the buildings, and sort of what a reasonable envelope around that would require. And that's per se liability, not the sort of harm-based liability that Cause B talked about for the immediate reaches and so forth. So that sort of extends per se, not a numeric idea, but based on what people are doing. Then beyond that, landowners have not actual possession, but they have a right to possess, meaning that they sort of have first dibs on building out into that space. So if building height restrictions don't apply, they would be able to build, and somebody operating airplanes or drones couldn't say, hey, I was operating my drone there, you can't build there. That wouldn't be the case. The landowner would have dibs. And in that zone, that's where the idea that airplane overflights would not trespass unless they, or drone overflights, unless they cause substantial harm or actual harm, that's where it would apply. And so you have this kind of petering out of possessory interest, but articulated through possession, the right to possess, and sort of petering out from there. All of which I think is consistent with a sort of reconfiguration of the concepts of possession, and is very, very, I think, consistent with the spirit of Cause B and the sort of policy questions that it addressed, but updated for the drone era. There are a lot of proposals for how to deal with drones, and I think that the common law can only do so much. I think my vision is that the common law, this, after all, a restatement is addressed to judges. The common law should address something that judges can do, the kind of things judges can do, and then legislatures, the FAA, and so forth will have definitely things to say, and are having things to say about it too.
Excellent. Thank you so much. We have two questions coming to you about the Fourth Restatement of Property. The first one is rather long, so I'll let you answer that before asking the second. But the first is from Andy Brigham, and he says, as the reporter of the Fourth Restatement of Property, you've said that you hope to create not only a coherent summary of property, but also to capture property's architecture to be more accessible to both those in the academy and practitioners. What is the broadest outline that you see that helps to illustrate what you hope to put into the final form?
Well, that's a great question, because it kind of gets to the project as a whole. So I think picking up on the answer to the last question, certain concepts like possession and notice and good faith and what a thing is are threads that are more or less apparent throughout the entire the entire project. And one thing that we've noticed is that when we do other aspects of property, land records and so forth, we wind up having to return to the very first sections. What is a thing? What is possession? What is all these very basic ideas. I think this is a little, countercultural in the sense that, post-legal realism, notions like possession, let's take that as, after all, it is a very, it appears to be a very important notion in the law, but people have had a hard time getting a handle on it. And the legal realist did a wonderful job of casting doubt on it. The idea that people use the term possession, but what they mean just completely depends on the context. I don't subscribe to that view. I think that possession is one of those notions that I think if we're clear on what the law can and can't do, it serves a limited purpose, but it is a very far-reaching purpose. It is a purpose that ties the law together, that frames questions in a good way, allows policy to be addressed through a lens that really puts the policy question in a useful light. So what do I mean by not doing everything? I think one of the problems that sort of 19th century legal formalism or system building and so forth, all these sort of taboo words that we have. One of the reasons that that was a problem was that they thought that they could write big treatises where you could summarize in very black and white ways what possession would mean with respect to every resource, that there's some kind of magic, a doctrinal thread that's going to tell us what it means to possess a fish, what it means to possess a chair, what it means to possess land, and that there's going to be some common denominator there. Whereas I think if you really look at the way property works, a lot of that comes as a matter of social practice, and the law tracks the social practice, the law filters the social practice, but the notions of possession that are sort of the glue that holds together these various areas is not the kind of sort of magic formula that explains that vast and incredibly diverse territory. And so I think one of the reasons, the realists did a service to point out that things that were not working, and I have to say that in a self-interested sense for the restatement, if we tried to restate all of social fact, I think that would be a problem. On the other hand, by concentrating on what we can do to address judges and other people about property law, I think property law can respond to those social facts in a better way, and it can be more understandable. So you might say that we got a little bit of a slow start in this restatement. I wouldn't say, I mean, it feels like a slow start, but one reason is that we spend a fair amount of time on how this would be organized, and I think the table of contents in an area like this is not an afterthought. I don't think of a restatement like this as a sort of a collection of sections, that there's really a lot of structure going on, and it's a work in progress. I mean, I don't think until we, 10 years or from now or whenever it is, I don't think we'll be able to say whether we succeeded in that or whether we really brought that out. But so far, that's how I think about it.
Professor, I don't think you could have walked more directly into the very last question. And I think after this, Professor Butler and Dean Spencer will take over. But the last question is, to what extent do you think the restatement fourth should attempt to improve the law and not just state the current practice of courts?
Yeah, that's always a perennial question with restatements. And everybody has their sort of idea about this. So I think that there is a constraint that I don't think we can put in the restatement something that a judge writing an opinion could say, well, I could never do that. That would be just, totally weird. Now that doesn't sound like much of a constraint, but that is a constraint. There is some constraint there, and maybe more of a constraint than that, but that's like the outer reaches. But within that, I think there's a lot of play in the joints in the sense that not only do courts differ on some of these questions, but the whole set of concepts has a certain flexibility and generative quality, and I think it's within the province of judges and therefore derivatively of restatements to reconfigure those building blocks up to a point in order to handle problems better. So returning to the questions of, trespass to personal property on the internet or drones or a variety of other issues, or adverse possession, which we have a very early stage sections on that, where we're proposing to allow adverse possession to function sort of to clear titles without reference to state of mind, but then allow restitution and equity to deal with the really bad faith exercises of adverse possession, but not condition one on the other. Let them operate in parallel tracks and let each do its job better than they would be able to do if they were conjoined together. Moves like that, which on one level I think look a little bit adventuresome, and I don't deny that they are. On another level, they're not that adventuresome in the sense that they're using tried and true tools just in a different configuration. And I think that goes back to the kind of complexity point, that property manages complexity. Sometimes it's mandatory, but it does have a sort of connectivity of its own. And I think that's one place that the restatement can accommodate necessary change by limited reconfiguration. So I sort of never imagined sort of how interesting that aspect of the project would be, and we'll see how it moves forward. So once again, thank you for all the questions. I have to say that I'm very much looking forward to tomorrow, but I've always benefited from hearing what people have to say at this conference, and we're already off to that kind of start. So I appreciate it.
Thank you so much, Henry, for your remarks. I know that I, for one, am really looking forward to what you have to add tomorrow, and also to the rest of the panelists' remarks. So we will see everybody tomorrow at the program. Thank you so much. Bye.
Thanks, everyone. Everything starts tomorrow at 11 a.m. So look forward to seeing you. Good night.